Morning, everyone.
Morning.
We'll call this meeting to order. Would the clerk please call a roll?
Commissioner Kemp?
Here.
Commissioner Jarvis? Here. Commissioner Warren?
Here.
Commissioner Snyder?
Here.
Commissioner Henning?
Here.
Commissioner Clark? Here. Chairman Wright?
Here. Just to mention that our county clerk is here this morning. The reason is Lynette Stanford, who's usually the clerk for the board, her father passed away last night. So we send her our best wishes. We always start our meeting with a prayer and a pledge of allegiance. Sherry, you want to lead us in prayer this morning?
Dear Heavenly Father, thank you for this fall season and the beautiful colors that are out there to remind us how gorgeous you made our earth. And Father, help us to learn to protect that earth. Father, we ask you today to give us wisdom and guidance as we make decisions for our constituents to always do the best that we can to give them the best service and the best that we have possible. Father, we ask you to protect all those that protect us. They have a different world out there, and it's always a different day. So please watch over them and give them wisdom in their job. In Jesus' name we pray. Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Before the board, you'll see today's agenda. We have a few issues to add to that agenda. We have a resolution considering the authorization and employment of corporation counsel. We're going to put that under other. A, additional items. B, we have a letter from the Veterans Board where they are recommending two individuals to fill vacancies, Mr. Scott Martin and Mr. Tim Spencer, and we'll put that on today. And, what we will do then is they will both be here next week at the meeting to introduce themselves. But these are their recommendations, so I told them we'll put it on there this morning, but next week I want to see the two individuals. I met them yesterday at the Veterans meeting, so that's where that's going to be at. We also have we need to put Mike Cox on the agenda today.
Would we put him on when he gets here?
Well, we can do that.
That way.
But we don't have too much on the agenda.
Yeah, we need to put him on the agenda to approve it, and then we'll just.
We just need approval to put him on the agenda, that's all. Okay, so saying that, I think I have everything, right, Mr. Biscoe?
Mr. Chairman, I would move the agenda with those additions.
Support.
All in favor, signify by saying aye.
Aye.
All same sign, motion carries. The September 27th, 2018 regular board meeting minutes.
I'll move to approve board.
Any discussion on those minutes? All in favor of the motion, saying aye.
Aye.
All same sign, motion carries. Commissioner mileage and expense sheets going around the dais this morning. You see anything that looks out of place or somebody spending too much money, please bring it before the board this morning.
Here, too much.
Everybody look at this. Nobody's spending too much money. That brings us down to elected official department head updates. Would any elected official or department head like to give us an update this morning? Teresa?
I will. Here, that's okay. Just an update about the ballots for the November election. They are now, according to the printer, all distributed to our local clerks. So there is a lot of transacting as far as wrapping up 80 ballots to go out into the community. So if at any of your meetings, any of your constituents wonders, they're in process, but they should contact their local clerk if they have a particular question. because I know there's a lot of activity going on, and we're happy that they're being distributed right now.
Thank you. Any other elected officials or department heads like to give us an update this morning? Hearing and seeing no one, I'll close elected official department head updates. That brings us down to first public time. Would anybody like to speak to us during the first public time this morning? Where's Alan at this morning? Hearing and seeing no one, I'll close the first public time. Bring us down to new and old business administration. We've got a revised training, registration, and overnight travel policy.
Mr. Chairman, Ian and myself, Craig, Doreen, and Evelyn all worked on this. There was a few additions after we did it that they thought would clarify things so that there'd be no misunderstanding. I don't know if anybody has any questions. You had it last week.
Speaking of misunderstanding, the only one that I thought might need to be one little change was on page 2 of 4 under single day training meetings. I understand that after each paragraph starts out for non-overnight training meetings, I understand that the parentheses is trying to define what that is, but in the second paragraph, it then sounds like it's either a typo or it's confused, because it says for non-overnight training meeting, leaving and returning to the county within the same 24-hour period within Lapeer County. So if it's a non-overnight training meeting within Lapeer County, leaving and returning to the county within the same 24-hour period is not necessary. It almost reads as a typo, and seeing as how that paragraph above describes what that means, I think it's just better to just strike that parentheses. So it just says for non-overnight training meeting, the department head shall, or I'm sorry, for non-overnight training meeting within Lapeer County.
Yeah, you're probably right.
Is everybody comfortable with this?
The only thing that
Because, for example, it's and I understand that when we have even like with the MAC thing now, MAC even like for the new commissioners, all of a sudden now the closest ones in Frankenmuth, but they're not doing it in one day anymore.
Yeah.
They're doing it in 2 days. So, well, I understand it may be stupid, but that's 2 days, and that's 2 days driving up there and driving back, driving up there and driving back. If you attend the thing.
And they're going to get less attendance.
Well, I'm not so sure. Well, that's not my issue.
because the first night is really nothing. You know, it was kind of maybe I read it wrong, but it looked like it was more of.
No, you read it right.
Okay.
Yeah, you read it right. I just curious. That was just an example. I'm sure there's other things.
Yeah. Well, that's what I was thinking. You know, because we don't have any hotel rate in there anymore. There is sometimes that people might be using a hotel where there's not a training attached to it. Like we've had some go to North Carolina. You know, they might not be able to drive there in one day. So we maybe should still keep that $75 in there for anything that's not attached to a conference. That's the state rate.
Any other discussion on that?
Well, I don't know that you can get very many places for $75.
I know, but that's the state rate. And that's what.
Well, on the state, on the governmental rates, you usually get. If you take the time to call a hotel and you're there under government rates, you usually get it. Still get it.
Well, I'm sure you can get the old Holiday Inn up on 46 and 75 right up there for $75. You probably pay to stay there, but I mean, that's the minute tile.
Another question, I guess, is those single-day trips, I think going to like a MAC committee meeting. If you're looking at that first paragraph that's added, it looks like you've got to submit a lot of data just to drive out of town, to go to a meeting. Is that right? Is that the intent?
Because we don't do that. If this is what they want, then we would have to do that. But that's a standing committee for us.
Well, no,
But
it's a standing committee for you. You volunteered to be on that committee.
Right.
But,
So is that supposed to-
anybody going to a one-day meeting and then driving right back, do they have to really, all they want is mileage?
Right.
Right.
Why do they need to submit all this extra stuff?
Liability. If they get in a car accident on the way there or the way back, were they on county business? We don't know.
So you need some kind of proof.
It's for liability.
Will anything, I mean, it's just a statement of the agenda, if there's a meeting or,
Well, like
some
for us,
meetings don't even, other than, it's a sort of a standing meeting, you don't even,
Well, somebody
you
put
don't
this-
have an agenda.
Somebody put these additions in there. Whoever put them in there needs to answer the
well, they
question.
were in there before.
You didn't bother.
But like for us, we wouldn't get liability insurance anyways if something happened.
And again, this is
Like, well,
mainly for employees, not necessarily for you guys who are going to.
Well,
because
committee
like
assignment
HDC, that HDC,
When you go over there, you're covered on the county's liability policy.
not really. I mean, if I don't show up, I get paid, and you know what I mean. Elected officials.
I didn't mean my comment just to be about commissioners, I meant about anybody from a department just going out of town for the day for a meeting.
I don't think people do that. If we want them to do it, we got to really start pushing this.
For them to just come into Joe's office one day and say, I got in an accident over in Shiawassee County. Well, what were you doing over there? I was going to a meeting. Well, where's proof you were going to a meeting? We don't know you were going to a meeting.
I would think though that could be pretty easily substantiated after the fact.
Your decision.
No, I'm just saying, I would think.
Let's just say I'm going and I give you the paperwork and all of a sudden I can't make it, so I ask Linda to go. It's last minute, so now she doesn't have the paperwork yet. So we fall in the same kind of category, but she'd be able to show that she was at that meeting. I think you're doing a lot of, they get crazy trying to follow her.
Did you guys discuss this at department head?
That has been on the policy.
No, I'm just saying.
That's not a change.
No, I'm saying before we go revising a policy, and all of a sudden, have we discussed this at department head? Hey, this is being reviewed again by the board, this is the reasons why, and like you say, liability, so.
But that, again, that wasn't a change. The reason we did this, a couple reasons. Was mainly the overnight hotel rate, and quite frankly, because it could not be followed, because it was $75. We all know that, you go to a conference, you're not getting $75 to cover a room. So that's the real initial intent and cleaning that little section up.
But we should go over all of them anyway.
Yeah, but I mean, I'm just saying that part of it didn't change. But you do need, I mean, even I would think that if I were director of the health department and somebody in one of the departments underneath me wanted to travel to Bay City for a meeting one day, I would want to know about that because I would want to know that they're going to be out of the office and what they're doing and where they're going and
again, that's why I ask, and I have no problem with cleaning that stuff administratively. I'm just a real big believer that from a teamwork perspective, these types of changes should be discussed with department head. I'd have no problem with moving it forward to a future COW, but I think it's worth A, avoiding miscommunication of any intent, and B, just to get any input. So if a department head says a procedure is too cumbersome, or we know that we have a lot of support for it, one way or another, administration could give us that feedback. So all I would like to see just before we put our final stamp on it is just for administration to report back and go, okay, you guys discussed this in full board a few weeks ago. You moved it to today until we had a chance to discuss it in department head. We discussed it with our department head. The majority of them felt it wasn't at all cumbersome. They understood the liability part of it, and we're good to go.
The reason we're still discussing it, Lenny, is because you weren't here last week. It's because the original one that was presented to the board, there was changes made after we had that committee of the whole meeting. And they weren't necessarily made by commissioners, they were made by administration and different things. So
most of those.
I brought it back and give it to everybody to take a look at and see if they agreed with all this
Yeah,
stuff.
no, I saw it on the emails and I reviewed it. And like I said, just before we put a rubber stamp on it, I would just like to know, as a former department head, I'd like to know the department heads get a chance to weigh in on this kind of stuff.
I do agree with Craig that actually probably the paperwork for liability reasons is probably necessary and should be done. I mean, when it comes to people, if they're gonna travel outside the county, they really need to put some paperwork in place so that everybody know where they're gonna be at.
So Craig, like I go to Mac Human Service meeting, so I could give you the yearly schedule, right? And then I'd be covered. You know, it's like HDC. They could give you HDC schedule. If the meeting's canceled, it's no big deal.
But when we do it, continue, like do AAA, you know, sometimes it's 3 times a month, you go over there.
Is that what you were looking for?
Not necessarily. Again, those are all scheduled meetings, like you say. I mean, it's the meeting we know nothing about.
And maybe we should say,
Well, those meetings are all scheduled because those meetings are also, you're assigned to actually, like Rick's assigned up there to
be there.
I mean, you know, those meetings, but some other meetings like the MAC meetings, there's no record of you being assigned to be there.
But
whatever, especially the way Dial does that.
This doesn't, I mean, it doesn't necessarily apply to us or elected officials because they're elected officials. They're a different category. This is really, you know, and we're not talking about the, what, 15 elected officials. We're talking about the 450 employees.
maybe we should say single-day training meetings for employees.
I mean,
We're actually employees, but we are a little bit different.
Can I ask,
I don't know why go ahead.
because I'm missing something, because under that paragraph when you said for a non-overnight training / meeting within Lapeer County,
That's what Lenny's was questioning because it says under that's the first paragraph.
but I thought that's what it was changed to.
All we did was strike out that parentheses that says you're leaving the county, and then it turns around and says within Lapeer County.
So you want that struck out?
Oh, the whole, okay, and
Just
so
the
you're
front-
not
just the
adding
front-
within the Lapeer.
No, all we're doing is
Okay.
striking out the parentheses.
Okay, I got you then. I thought you were striking that out and adding. Okay, that makes sense then.
Teresa, did you get that? What we're striking out?
I believe so. It's the second paragraph under single day training
Yeah,
meetings.
just the parentheses.
What do you want? What's inside the parentheses?
Yes.
Okay.
Will there be a revised version that'll be adapted for the minutes, or is it going to be an edit?
If there was a bunch of revisions, then yes. If that ended up being the only thing, then we would just say that we passed this or we moved this with that one correction.
I'll move the policy with that correction to the next full board and ask administration to send it out to department heads for their comments.
Fair enough. Is that the only thing we need to? Okay. Well, then we need a motion to do that. You made the motion. A motion and support. All in favor of the motion, so saying aye.
Aye.
Both same sign, motion carries.
Yeah, I agree.
You should be here pretty soon. All right, now. Well, we can. Got to, let me see.
Audit motion.
Well, wait a minute, we got other things that's on here.
Do we want to do the draft one?
One by one.
Are we gonna do this, are we gonna
Could
do
we
this?
take a 5-minute break?
All right, we'll take a 5-minute
I'm
break.
requesting a 5-minute
Somebody's got to
break.
go to 5.
We'll do a 5-minute break right now. Discussion on this.
It's not attached to our packet, we should probably read it out. I saw it, but I didn't see that. I don't have a copy of it now.
Does everybody else have a copy of
I don't
it?
think they, I don't think they,
Dial has it, Ian has it,
I think they
Rick
put it
has it.
on, I printed mine.
Well, we're not the privileged ones. I just seen it on your desk.
Where's John? It should be.
Let's go, let's get some,
Maybe
let's
should
get
get
some
a couple for the
copies.
public too.
There, get some copies. Josh, where's
She got them?
Do you want me to go upstairs and make a copy of yours? Okay. Okay. Just go
No, you
to-
don't need to go upstairs, Meg. We'll have them made and sent down.
Okay. Just a.
6 or 7?
This stuff came in this morning, so
Yeah,
we're
tell me
trying
this
to
is
get.
it. Hi, can you make about 15 copies of the resolution for Corporation Council and bring them down to the commission? Thank you.
Can we do something else while we're waiting?
Sure, you can do, we can do the,
Draft motion?
I'll move the draft motion.
oh, wait a minute, why don't we take care of the veterans thing first?
I'll move to nominate Scott Martin and Tim Spencer to fill those vacancies at the Veterans Affairs Committee.
Support.
Move nominations be closed, unanimous ballot be cast.
Support.
All in favor, signify by saying aye. Aye. Opposed, same sign. Motion carries. Those two gentlemen will be at the meeting next week and during elected official department head updates. They'll just introduce themselves to the board.
So they do that.
That one,
Yes.
we're still waiting on copies of the resolution, so, okay, you want to do the draft motion?
I'll move the draft motions, 1 through 5 is a consent motion.
Is there a question on the one?
Mr. Chairman, I would suggest on it too, you delete the, which will be held on October 25th. We're not quite sure the timing may not work, given the ebb and flow of the budget, but the authorization there is published. Once you give the draft its approval, we get it published.
So you want to just delete the October 25th?
To be determined, maybe?
Just authorize it to be published, and once you complete your work on the draft, we'll just put it in cycle and get it published.
So you're saying, leave it as it is, just take out the hard date.
Right, that's all I'm, right. That way,
Was
we
it
can
on-
keep it moving.
Is it on display now?
No,
No, it's not.
you haven't done a draft budget. Once it's done, we'll put it on display and get the publication out. I'm saying that date, you may have to alter because it may be, we may not hit that date with the budget. You may have some other changes you may want to make.
That's fine with me.
The only thing, we got to get it done so the townships can do their work, and that needs to be done by November 1st.
So, you could, I'm not suggesting that you can go to the end of the year.
I know we can, but they can't.
And there shouldn't be any delays. I think you pretty much have got, I believe, your working draft about done, and we'll have that session today, and hopefully it'll be finalized.
Do you want to just move it to November 1st?
If you want to put a special date, a particular date, but what I'm saying to you is that if you have no issues, it may be an earlier date. If you have other concerns, it may be a later date.
Okay, so for my motion, I would just remove
October.
which
Will be held, yeah.
to calendar. And a period after hearing.
Okay. So on motions 1 through 5, with the changes on 2, all in favor of those motions, signify by saying aye.
Aye.
All same sign, motion carries.
Mr. Chairman, I'd move the audit motion with the controller's signature, and I'd move the road commissioner's audit motion.
Support. Will the clerk please call the roll?
Commissioner Clark?
Yes.
Commissioner Henning?
Yes.
Commissioner Jarvis?
Yes.
Commissioner Kemp?
Yes.
Commissioner Snyder?
Yes.
Commissioner Warren?
Yes.
Chairman Roy?
Yes. We spent $12,609,613.83 this morning of hard-earned taxpayer money. That brings us down to the second public time. Would anybody like to speak to us during the second public time? Hearing and seeing no one, I'll close the second public time. Bring us down to commissioner reports.
It's time for you to do your soft shoe.
Let's do my soft shoe. We can do the commissioner reports. John has something that he wants that came out of personnel, right?
Mr. Chairman, I would recommend you give yourself authority next week to adopt the job description for the new coordinator incident counsel. We'll get you the draft to look at today. As you know, that's still in a state of flux in Lansing. Apparently some of the other counties are now balking about signing contracts. We've had discussions with the chief judge, so incident counsel is continuing as we've always seen it functioning, because obviously it can't stop, because the legislation says October 1 was, of course, the kickoff date for the new plan. But there's quite a dispute about funding underway, it appears.
There's some lawsuits, isn't there?
I'm only aware of one lawsuit. I'm aware of one other county that's refused to sign a contract. But if you read the MAC legislation, you'll see there's negotiations underway and a period of disputes between the commission and what the legislation actually says as it relates to funding. That seems to be turning on that. Also, some other questions have not been answered yet about what happens if you exhaust the budget the state gives you, then who picks up the difference. So we need to keep moving. We're moving on facilities. We need a job description in place, because obviously we've got to post it and start going through a selection criteria, but we're still dependent upon what the state ends up doing.
Would you bring that to us next week for the job description?
Right,
Please
but
bring what it could cost the taxpayers of this county. Because that's a new position.
It's a brand new position.
Yes, brand new position.
All I can tell you right now, and you've already passed it, is the application's gone in, the revised budget's been submitted, it has not come back from the state yet. So we can give you what the revised budget is. Purportedly, it's paid for by the state, of course, with our cost share.
We don't have a contract yet, do we?
We do not have a contract, and some of the counties with contracts are not signing them.
Most of it.
Most
I
of
don't think
them.
any of them are.
That's something that I usually don't do. Sign one.
What would be the reason that we would need to pass the job description before receiving the contract?
It's my belief it's going to be resolved. It's clearly legislative. It's in place. Somewhere there'll be a resolution of the issues. We still have, even with the adoption of the job description, probably a month to post to select. So we're still talking about November anyway. So a week or two could be significant to us, particularly if we get a contract that's acceptable to the board.
That was my question.
It's just a matter of trying to position ourselves to be reactive to whatever comes down from Lansing. Don't have to, that's true. But right now, if we did have a contract, we have no authorized position and no adopted job description. So if that contract hit tomorrow, we still have to go through the spin anyway. So it's a preemptive thing, if you will. That's all it is.
We have the additional. We asked for additional copies of this resolution.
So per John's request, I move that next week we give ourselves authority to act in the matter of indigent counsel job description or items related to that new position.
Yeah, I'm not sure there's a rush.
Well, so
I'm not sure
if we
there's a rush
see
either.
something,
That's why I brought
so if we
that up.
see something next week, there's no reason why we can't continue to move it. But if for some reason we all decided to act, we wouldn't be able to without that motion.
Yeah, what we're doing is rather than posting it.
So you got a motion? All in favor of that motion, say aye.
Aye.
Both same sign, motion carries. This doesn't mean that we're going to actually,
Right.
it's one of those.
We have authority to do something.
It's one of those issues that the state brought to us. John, we're waiting for some copies of this resolution. Some of the board members don't have copies of it, so we requested from
We
upstairs.
requested from stairs.
And because it's not on the agenda, we want the public to be able to have it.
You need a quick.
We're gonna have a copy.
Did you get a copy?
I'm not sure that we should.
I'll give you a copy, but I don't have a hard copy.
I don't.
No, you can keep it.
You can keep it, we've called for to have additional one brought out.
Here, Tiger's bringing down copies.
They're two down or way down.
Bring it
Those
over.
aren't Tigers.
Maybe they don't, huh? Yeah, well, that's true. Maybe they're looking for one upstairs.
Yeah, but you're calling it.
Yeah, I would think that's.
Are those copies on their way?
I think they'll get them. They said they gave it to Craig.
That is right.
This is by Management 101, they say she'll.
Okay, thanks. I see you said they're running personnel ones too.
Those are what he requested for, what you just pushed through.
Well, they're behind. They're waiting for me. They're already falling behind. Morning, Mike.
Should we go ahead with
Might as well.
Mr. Cox?
I think so.
Mr. Cox, how are you this morning?
Very good, thank you. Everyone seems pretty chicken this morning.
Yeah, well, we're in pretty good shape this morning, so you want to proceed with this?
Good morning, Mr. Chairman and the board.
Good morning.
When we last spoke in closed session, you gave my office an assignment. And what I'm going to do is, I don't want to kill you with paper, but I may just do that.
That's an attorney's job, right?
We have an exhibit packet, and then I have a memo, and the first 5 or 6 pages cover stuff that we had discussed before in the last closed session about some of the facts, but it's in the memo in case I didn't know what would happen with the memo. It's my understanding that the board wants to proceed with it and thinks it's appropriate to proceed with an open session. And so, in fact, it probably makes sense. I'll walk back through the facts briefly, but the memo will cover in greater detail. And then I'll get into the questions that were asked of me the last time and the answers, the responses that we have. So let me just start with, maybe I'll send the packets one way. And
Yeah, the board feels that this should be done in front of the public.
Thanks, sir. He's got the other one. That's another one.
you all good on All right, well, we'll start right at the beginning. Usually that's the best place to start. If everyone's set with both the memo and the exhibit packet. Okay.
John, we need one with the board, if you guys give one problem.
Memo or exhibit packet?
Exhibit package.
Yeah. Try one.
Okay, to refresh everyone's memory, even though it's just a couple of weeks ago, there have been a lot of discussions about potential liability growing out of Mr. Sharkey's representation of Judge Conshu. And by that I mean some of the factual matters that came out in the course of discovery, which is becoming public knowledge. And so this board asked our office to look at, would any of those facts potentially lead to any liability for the county itself, for the Board of Commissioners, for any of the employees, for any of the officers of the county, including Judge Conshu as well as Prosecutor Sharkey. So the three specific questions is on the cover of the memo is, number one, is there any potential county liability that the taxpayers would have to bear growing out of the fact that cases have been tried by Mr. Sharkey's office in front of Judge Conshu, and Judge Conshu owes Mr. Sharkey over $400,000 in a personal debt. Now, question number two is then, dependent on the county's insurance policy, does the county's insurance policy cover any litigation costs or any resulting damages that could happen if someone sued over that conflict that arises from this $400,000 debt? Related to that, are there any disclosures that the county should make to its insurer? Then the third general question is about indemnification. Does the county have to indemnify Judge Conshu? Does the county have to indemnify Mr. Sharkey or anyone else in regard to any claims or damages that could arise from a lawsuit by a private citizen regarding any of the matters touched in a courtroom by someone from Mr. Sharkey's office where Judge Conshu was presiding? And the short answers are, because of the concept of governmental immunity, which is absolute for elected officials, it's highly unlikely that, despite the fact that there is apparent ethical problems that arose from the debt, it's highly unlikely that any of the liability, financial blowback, could come back to the county. And I'll go into that a little bit more in depth. However, if it did, the county's insurance policy with MMRMA, Michigan Municipal Risk Management Authority, does provide coverage for both Judge Conshu, for Prosecutor Sharkey, for the board, and largely for the county and its employees. And then third, the county does not have to provide indemnification for Mr. Sharkey or Judge Conshu. That's a matter of policy, and that's a choice. There's no statutory requirements in that regard, and no reason for this board to do so. And certainly, if in fact given the insurance coverage by MMRMA, there doesn't appear to be a practical need for that to be provided either. So let's roll back, especially for the members of the public who are here. This might seem like the end of the story, and I should start with the facts that were given myself and my office and the information we've garnered from different employees of the county and the court system, and the information that's been relayed to us from a variety of sources. So as this board knows, currently Judge Conshu is suing the county and a number of individuals affiliated with the county. And in the course of that lawsuit, Judge Conshu was deposed by an attorney on behalf of the county and the officers and employees. And on November 15th of last year, that happened. And in the course of that, he was asked a series of questions about what are your damages, which is very common to ask a plaintiff in a lawsuit. And then the lawyer breaks them down one by one, or A, B, and C. And in the course of that, Judge Conshu, as we have in the footnote on page 2 and runs on the page 3, was asked this question. So what exactly are your damages in this case? Answer, I paid out of pocket so far $60,000 in attorney's fees and related expenses for the mediation, comma, the expert witness, and I have an outstanding bill to Mr. Sharkey that exceeds $400,000. Question, a bill for what? Answer, legal services. Question, has Mr. Sharkey agreed to write that off? Answer, no. And that's from the transcript of the deposition of Judge Conshu. So that presents, or can present, a problem, can present ethical and potential liability problems if Mr. Sharkey or his assistants appear in front of Judge Conshu and the other side doesn't know about it. Clearly, none of us, I expect, want to go into court and be in front of a judge where the other side's attorney was owed $400,000 by the judge. You would wonder whether the judge can ever side your way. That's just a commonsensical point. And in fact, the Michigan court rules, which provide rules for all lawyers and a subset for judges, has addressed this. There's a court rule which we outline on page 3. That's Michigan Court Rule 2.003, sub C, sub 1. And there are, among other things, there are 3 different ways that a judge should be disqualified or recused from presiding over a case. And the first one is pretty obvious, is the judge is biased or prejudiced for one side or the other. And that's where it's eminently clear. The second one is where objective viewers, reasonable people, would look at it and would not be able to say that there's actual bias, but from the facts we know, there's a serious risk of actual bias arising. And then the third is there's the appearance of bias or impropriety could be happening. And so those are the 3 things oftentimes when lawyers say to a judge, I'd like you to recuse yourself. It's usually one of those 3 reasons that's cited. And here, at least the latter 2 appear to do apply. I'll go with the second. Would an objective and reasonable observer say that there's a serious risk of actual bias if Mr. Sharkey appears as a lawyer, or the lawyers who work for Mr. Sharkey appear in front of Judge Conshu? And I think the reasonable person would say yes. And that grew out, as I informed this body before, that grew out of a U.S. Supreme Court case where in a heated election just a couple weeks out, a person who had lost at the trial court gave $3 million to the campaign of one of the West Virginia Supreme Court justices. And afterwards, that case went up on appeal in front of that justice, and he refused to recuse himself. And the United States Supreme Court said, look, a reasonable, objective person would look at that and say there's serious risk of bias. Well, here, in that case, that was about a political donation. It wasn't about a personal debt. And it was about a political donation by a very wealthy person. Here, there's $400,000, which is a huge amount of money for a personal debt. And so clearly, if the U.S. Supreme Court could say that there's an objective person would say there's a real risk of bias there such that the judge should recuse himself, it's clearly the case here. And so under the Michigan Court Rule 2.003C1, there's the objective risk of bias, and there's also the appearance of impropriety. So either one of those bases would give rise, at least minimally until the debt's paid off, that Judge Conshu would be biased towards Mr. Sharkey or lawyers who work for Mr. Sharkey. As we know, and common sense tells us, one of the ways people are evaluated in an elected office is their performance. And one of the ways a prosecutor is evaluated is their conviction rate. So if one's a criminal defendant in front of Judge Conshu and doesn't know about this, strike that. If one knew this going in front of Judge Conshu, there clearly would be concern and you would move to recuse Judge Conshu. I think that's just pretty commonsensical. So we garnered those facts and we looked at the rules, and And I think it's not really open to controversy that is an ethical issue. Now, so we then looked at the record. Since Mr. Sharkey assumed office in January 1 of 2017, had he or his office appeared in front of Judge Conshu? Well, back last January of 2017, I'm trying to move this quickly, but there's a lot of facts here. Back in January 1 of 2017, at that time, Judge Conshu had been assigned by Judge Holoka to handle two types of cases. Criminal matters in the district court, that's number one. And the other was a smattering of family division cases that Justice Scott wasn't handling. Among those were personal protection orders and delinquencies. At any rate, we found during the first 6 months of 2017 that Mr. Sharkey's office appeared in front of Judge Conshu on 242 different matters, and criminal matters. And now at that time, Judge Conshu had some awareness that there's that his prior representation by Mr. Sharkey might pose an ethical problem. So he posted, and we have an exhibit there, he posted a notice to all the lawyers which recounted, and I'll have to walk this through for you, so it recounted the history of Mr. Sharkey representing Judge Conshu. That Judge Conshu had been investigated for an embezzlement, that he'd been prosecuted, that had resolved himself with a no contest misdemeanor plea, and that Mr. Sharkey had represented him during that period of time. That was put on the desk for the attorneys to let them know about that. And as I write in the memo, if the only conflict were that prior attorney-client relationship, that notice would have been more than adequate. Because a criminal defense attorney or a criminal defendant walking in there could see the notice and evaluate for himself or herself, is that the kind of thing that's going to lead me to believe that the judge is going to be biased against me or against my client? Now, if you just say it's a prior attorney-client relationship, a professional relationship, most lawyers, I've been one for 30 years, would say, I can live with that. Okay, that happens. Lawyers end up as co-counsel. They end up across from each other. They have fights and they move on. And some of them become judges, and you move beyond that. It's just a matter of the professional business. And so I would say that notice, if that's all there was, would have been more than adequate by Judge Conshu. However, as we learned from the deposition, at that time, there was this $400,000 personal debt. And if any lawyer knew that the lawyer on the other side was owed $400,000 by the judge, and it wasn't just some professional there'd been a professional relationship in the past, but in fact it was a $400,000 personal debt, no lawyer would, even if they thought highly of the judge, no lawyer could let that slide and would move to recuse. Well, that opportunity wasn't presented to the lawyers that went into Judge Conshu's courtroom during the first 6 months while he was performing the criminal district court matters. Now, so could that give rise to a lawsuit? It could. But there's two limiting factors. And one is all the felony criminal cases, if they're bound over for trial, would have went up to Judge Holoka, where the ultimate trial would have been any sentence and conviction. So it's very, so if Judge Conshu did something in a biased manner to help the prosecution out, presumably it would be rectified at the circuit court level. So that reduces potential liability. However, for misdemeanor cases, which could be drunk driving, simple assaults, can lead to imprisonment up to a year in the county jail, those would have all been handled still by Judge Conshu. And that could give rise to someone in a couple different ways. Obviously, appeals. So we, go up to the circuit court, the court of appeals. Someone could say, this is the kind of fact, I wasn't told this. If I knew this, I would have moved to recuse the judge, and it would have mattered. And so that could increase the cost of criminal appeals and retrials, which would cost the local communities, townships, and cities more monies to put their trial back together, find witnesses, that sort of thing. On the civil side, it could lead to civil lawsuits by someone saying, I was wrongfully imprisoned because I didn't know about this fact. But again, it wouldn't be for, like we sometimes see these people been in prison for 30 years. It would be for shorter sentences. So in that sense, there's two potential ways that liability, increased cost could happen. The cost of a new appeal or a lawsuit, okay, a civil lawsuit by a plaintiff. Let me move over to the family division cases that were being handled during that 6-month period of time. Hopefully you can hang with me. From January of 2017 to July of 2017. At that time, Justice Scott handled most of the family division matters. But Judge Konshu, by Judge Holoka's order, and you have to bear with me here for a second, would handle personal protection orders and paternity actions. Okay, personal protection orders in many counties the prosecutor handles. I haven't been able to determine if that's the case here. Sometimes it's just personal lawyers. But oftentimes the prosecutor handles. Paternity actions generally are something that the prosecutor handles on behalf of the Department of what used to be Community Health, or Health and Human Services, to establish paternity for Medicaid purposes, right? So in that area, there could have been situations where assistants of Mr. Sharkey were handling family division matters in front of Judge Konshu. However, the information we received from some of the employees of the court system is that Judge Konshu actually handled some other matters too beyond the order, including child protective service hearings and delinquency matters. Now, child protective service hearings can lead to bad results for a parent, could terminate parental rights, probationary counseling, and those folks could come and say, hey, my lawyer didn't know about that, and if he or she did, we would have moved to recuse Judge Konshu. So there's a potential they re-motion and ask for a new day in court, and maybe some civil liability there. Now, if there's a parental termination, those are pretty rare. In a county like Lapeer, I don't know how often they happen, but that could give rise to some civil liability. Okay. And I don't want to go too deep in the weeds, but in July of 2017, Judge Holoka issued a new order. And he said, from now on, Judge Barnard, who's a district court judge, is going to handle all criminal matters at district court level. So no longer would there be this issue of the prosecutor's office appearing in front of Judge Konshu for criminal matters. However, Judge Holoka then handed child protection matters, delinquency matters to Judge Konshu's mix of cases, and those would at times give rise to the prosecutor's office appearing in the family division in front of Judge Konshu. We don't have the numbers yet for that. It's an awful lot of work, and we based on the direction you want here today, we didn't want to get ahead and incur a lot of expense. If we could at least provide you some information to make decisions. Okay, so those are the facts. Okay, before I move on to governmental immunities, anyone have any questions about the facts? Okay, because there's a lot there, and it can be eye glazing, which I get. So as I said, there's potential for criminal appeals, which could cost some money. Now, some of those time lengths would pass, but if someone found out about it, the potential is there to file new motions. I don't know if that will happen. Can't predict the future, and there's a potential, let's say there's some civil claims. Could a person pursue a civil claim based on what I described for you, where the judge had a clear conflict, should have recused himself, but he didn't? I will say this, I was asked about, is this a conflict for Mr. Sharkey? The rules aren't as clear. There's a case I cite in here, People versus Doyle, where the Court of Appeals says when it comes to prosecutors disqualifying themselves, they should keep in mind that their job is to do justice and to also look out for defendants. That may sound a little contrary to what you see on TV, but they have, as an officer of court, they have an obligation. But the rule isn't as clear as it is for judges. So clearly the rule one would have expected, and that the judge would have recused himself. In terms of Mr. Sharkey, it's a little less clear as to whether he should have. And I'll just leave it at that. So what's the potential exposure to the county? Why don't we move to that? Well, as I described, there's 3 pots. There's the 6 months in the district court for criminal matters. That's pot number 1. There's the family division, the small amount of family division cases in the first 6 months in office. That's pot 2. Then there's a third pot where Judge Conshu now has a more full family division docket, where he does handle child protective hearings, which are handled by the prosecutor's office. He handles truancies, which in some counties are handled by the prosecutor's office. Handles PPOs, which in some counties are handled by the prosecutor's office. So there's 3 pots. So should you be worried that this can cost the county money or lead to lawsuits against either Judge Conshu or Mr. Sharkey or the county or this board or employees of Judge Conshu or Mr. Sharkey? And the answer is people can file lawsuits. But because of the concept of governmental immunity, I expect that if lawsuits were filed over this, what I call the debt conflict, which is that clear ethical problem, if lawsuits were filed over this, it would be my opinion to you today that your insurance carrier's lawyer would be able to get the cases dismissed on the idea of governmental immunity. And let me just talk in general, what's governmental immunity? And some of you in your time here may have encountered the concept before. But the idea is, and it's been around for a couple hundred years, is that we don't want the main decision makers in government, either through the branches, being intimidated from making decisions if every decision is going to lead to a lawsuit. And I'm going to read you a little bit from the U.S. Supreme Court that talks about this and why it matters when we get to Judge Conshu. But the idea, and so what has happened is in both cases and Michigan State statute, there's a Governmental Tort Liability Act, GTLA, which you may have dealt with before with your insurer's lawyer. At any rate, there's statute and there's a number of federal cases that gives broad governmental immunity to elected officials like Mr. Sharkey, to judges like Judge Conshu, to the board, and to a lesser extent, employees. But let me just, as a background, let me just read you. So in the memo now on page 9, I dealt with first Lapeer County. Could Lapeer County arguably be sued for any of this? And it would be a couple different claims. It would be a state tort, like intentional infliction of emotional distress, or it could be a 1983 action, which from your time in government, I expect you've heard of. That's a federal claim where someone's constitutional right, here the right against imprisonment or loss of money, was impacted or impaired under the color of law, meaning by a government actor. So let's look at Lapeer County first and foremost, because that's your number one concern here. Will Lapeer County have governmental immunity on a potential civil lawsuit here? One of the state General Tort Liability Act, I'm now in the middle of page 9 under the heading Lapeer County. there under subsection 1, there's broad protection for governmental bodies like Lapeer County. Now, in 1983 action, a federal court action, you have less protection. The state of Michigan, under the 11th Amendment, has complete immunity. Its subdivisions have less. If someone could allege that you had a course of conduct that is a county policy that caused an injury, then you could be subject to 1983 action. Okay? But the reality is, you as the board here cannot tell Judge Konshu to recuse himself because of separation of powers. You don't have statutory power to do that. So it isn't your policy, it isn't your custom for Judge Konshu to not recuse himself. So what I expect that you'd have full governmental immunity for both state claims and federal claims. Let's move to Judge Konshu. And despite what I see as an ethical issue here, he would have full immunity. And as I put in the memo, I don't work for the Attorney Grievance Commission, my lawyers don't. I don't work for the Judicial Tenure Commission, my lawyers don't. They may have a different view. I'm just going by the plain language of the rule, and also 30 years of practice. But you know, sometimes in the law, someone might, even though someone commits an ethical or professional misconduct, that doesn't always mean that they can be sued for it. And that's the case here. Here, we have a state statute, the same one, the General Tort Liability Act, which says that subsection 5, a judge, a legislator, and the elective or highest appointed executive officials of all levels of government, end of quote, are immune. And so judges are immune, or have broad protection under state law. I cite here in the middle of page 10 some federal cases which say that if the judge is performing a judicial act, that he has federal immunity as well. In fact, I put a quote here, and to give everyone, but more so the public, an idea why immunity is given even if someone does a wrongful act. There I quoted from the U.S. Supreme Court case of Pearson. And there the Supreme Court said, quote, this immunity, meaning to judges, applies even when the judge is accused of acting maliciously or corruptly, and it is not for the protection or benefit, strike that. This immunity applies even when the judge is accused of acting maliciously or corruptly. And so you scratch your head and you say, why would you provide liability for that, or protection? And there they go. Then it goes on to say, because the protection, quote, is not for the protection or the benefit of the malicious or corrupt judge, but for the benefit of the public, whose interest it is that judges should be at liberty to exercise their functions with independence and without fear of consequences. And you can understand that. If judges could easily be sued, anytime someone had a bad outcome, they'd want to sue the judge and bully and try and punish the judge. So there's this broad immunity, even for when judges act corruptly or maliciously. And so that covers Judge Konshu. And I expect if he is sued over this conflict and not disclosing it, and permitting Mr. Sharkey's lawyers in his courtroom, and not letting the other side know, even if he's sued over someone said, I was damaged somehow by that, he'd have absolute immunity. Excuse me. So then on page 10, I move on to Prosecutor Sharkey. And he is provided with broad immunity under state law, both from the General Tort Liability Act, there's cases that are cited, in the same way his office is as well. So that would cover his employees, who, if you think about it, if they're just doing what the boss says and they're appearing in front of the judge and they don't know about the conflict, they shouldn't suffer the consequences. I've also cited that that more than likely, and I can say almost absolutely, court employees have the same immunity. But I cover that in some footnotes, and if you have questions, I can follow up today or later on if you want to call me. Okay, so the bottom line is we found what we believe to be an ethical issue if the facts are as we learned them. Okay, that there was 240 plus appearances by the prosecutor's office during the first 6 months, and there's still occasional appearances now in front of Judge Conchu. That's an ethical issue, and that's something for the Judicial Tenure Commission. Let's move on to the next question. And spent a lot of time in that first question, but it had a lot of facts. It moves a lot more quickly after this. So, does your insurance, if in fact the county and the county officers such as Mr. Sharkey or Judge Conchu or county employees couldn't get out on governmental immunity, are you covered? And the answer is yes. The MMRMA was, those are some of the toughest acronyms. At any rate, in their policy, I'm now on page 11 and 12. They don't call their policy an insurance policy. It's a liability motor vehicle physical damage coverage document. At different times, I wouldn't be surprised if some of you have seen it. But anyway, it says, in the relevant part, it will pay on behalf of all members, all monies the member becomes legally obligated to pay as damages to another person for 6 different topics. And it even includes wrongful acts as one of those 6 different topics. And members include the governmental body, meaning Lapeer County, includes employees, includes elected officials. And that's elected officials is directly in the policy, which should cover Mr. Sharkey and Judge Conchu. Separate from that, they also add a rider, which I checked with Mr. Manser, who's your broker, and he said that, in fact, Judge Conchu is covered under the language and the rider, as are employees. So if it got beyond, if your insurance lawyer couldn't get the claims knocked out on governmental immunity, your insurance lawyer would still continue on. MMRA would pay for his or her costs and would pay for the damages as well. But leads to the question, do you have a duty? Do you have a duty to tell MMRMA about what I call the debt conflict? We looked at the policy, and now I'm at the bottom, page 12, top of 13. And it says you have to report occurrences. And occurrences, they define, and they have the exact language there in the memo. But basically, it's an event or a continuous and repeated exposure to the same general condition which causes or is reasonably expected to cause damages. Now, from a plain reading of that, because of the idea of governmental immunity, I would say it's not reasonable to say that this conflict, even though it's an ethical issue, this conflict isn't likely to cause damages that someone could collect on. It could cause a lawsuit, but it's not reasonable to think that they could collect on it because of governmental immunity. So I would say the strict language of the policy, you don't have to report it. But moving beyond being the lawyer, I think it's a prudent matter, you should report it. There is a section 7, which talks about member duties and responsibilities. And there the document says, quote, this coverage document is void if the member at any time intentionally conceals or misrepresents any material fact or circumstance relating to the coverage document or any claims made under the coverage document. MMRMA could arguably say, you should have reported this, or it was close enough. They say close enough in horseshoes and hand grenades. I think there's a clear legal defense, and it's not reasonable to think that anyone would ever have to pay damages. But I think the prudent thing to do would be to report this to MMRMA. Under the language, you'd be going beyond what you're required to do, but it would prevent any later litigation if in fact a lawsuit occurred over whether the coverage applies. The last topic was indemnification. And after that, I'm going to bring up one last thing about governmental immunity. Indemnification, quite a while ago, the Board of Commissioners were indemnified. I don't know the exact circumstances, and I don't know what the status of your insurance coverage at that time was. The commission or the county isn't required to indemnify anyone. Okay, that's generally negotiated by parties. Oftentimes it happens in the private world, but the state doesn't require any governmental body to indemnify certain people, at least not in this setting. So there's no requirement to indemnify the prosecutor or Judge Conchu. And quite frankly, the insurance policy covers them in that regard, and it's good enough. It's all lawyers. No lawyer ever speaks without giving a qualifier. So I should say this. The governmental immunity, I think, is as absolute a defense here as you could get. But I will tell you, and we looked hard, and at some point we had to stop and say, we don't want to be wasting any of the county's money. But we couldn't find any factual situation like this anywhere, in the ethical area or in the, in reported cases. So I think it's a reliable prediction that governmental immunity is, would have you out. There could be some other facts that I'm not aware of that developed, but from what we know now, the governmental immunity is a strong and broad defense and would act as a wall to any damages ultimately happening and impacting the taxpayer money of Lapeer County. And now that being said, someone could still sue, and so but presumably your insurer would take care of it. But there may be ultimately, and I don't know those 242 cases, what were the outcomes, whether people went to jail, how they would feel about it. There may be some increased costs from a possible appeal, but I don't have enough information to say anything more than that. So I know I've thrown a lot of information at you, but so if you have questions, have at it.
You were extremely thorough, Mike.
Yeah.
Okay.
Basically, in the summary of things, and what we were really asking about specifically was the fiscal impact. Yes, thank you to the county. And your summary is that while there could be a lawsuit, there probably is not a lot of fiscal impact to the county.
Commissioner Kemp, you're exactly right.
In a nutshell.
Yeah, there's a lot of pages, a lot of trees killed, but that's the conclusion.
And it's not likely to happen. It's if there are suits, I assume that our rates with RMA would rise. But again, if there aren't suits, there's no issue.
Right.
But the problem with suits of any kind, once somebody files a suit, we may not be liable, but it'll take 2 years for us to prove we're not liable.
It's a lot of energy.
A lot of energy, a lot of expense, and everything else. I mean, to prove that, as you know, what happens in the courts today, because it takes about 2 years to 3 years for anything to get resolved.
I mean, and Mr. Chairman, you're absolutely right. I didn't cover that here. There's a lot of energy, employees running around. Even if you ultimately don't have to pay the dollar, you lose a lot of time from your employees trying to prepare. And then the public scratches its head and wonders if something was done wrong as well.
Well, I mean, quite frankly, I also did a little bit of research, and I'm certainly no attorney, but I didn't have to really get past the Sixth Amendment to the U.S. Constitution, which guarantees the public the right to a fair and speedy trial, fair being the key word. That's extremely troubling to me. So,
and I understand it, and part of the Sixth Amendment is the right to counsel, and part of the right to counsel is fully informed of all the facts of what's going on. And so counsel, you can't fully exercise that right if you don't have all the information. But that's really for a different tribunal,
right,
than this board.
So thanks for this exhibit packet. I mean, it took a long time to research all this, I'm sure.
And I'll tell you, part of it, one of the biggest things is trying to foresee possible claims and avenues. So it's a lot of disproving a negative, which which takes time.
Mr. Chairman, I would just move that we receive the packet from Mr. Cox.
Support.
Have a motion and support. All in favor of the motion, say aye.
Aye.
Both same sign. Motion carries.
Thank you.
Thank you, sir.
Thank you. We have one more issue.
Do we have
the resolutions now from Mr. Cox upstairs?
Additional copies.
have the resolution? We asked for additional copies of the resolution.
They came down.
They got
We
it.
got it.
Oh, you got it. Yeah, they got it.
And does the public have them too? Because they weren't.
Are they available?
They're right here.
To the public.
We asked for physical. There was some right there, right here.
I have one.
So in other words, Cheryl had them.
Give me Eric.
I didn't see them.
You want to take one? The rest of the people?
We have a resolution here. And I think I should maybe read it for the public. So I'll do that. And this says a resolution authorizing appointment of corporation counsel. At a regular meeting of the Lapeer County Board of Commissioners held October 11th as of Lapeer County Complex, 255 Clay Street, Lapeer, Michigan. Whereas the Lapeer County Board of Commissioners Board is authorized under Public Act 15 of 1941 by a majority vote of the members elected to employ an attorney to represent the county in civil matters. Whenever the board determines that the prosecuting attorney is unable to properly represent the county, and whereas the board needs independent, impartial, and unbiased legal counsel to represent the board in all civil matters relating to Lapeer County, and whereas the prosecuting attorney has stated repeatedly that his office is currently unable to handle its current caseload, which includes both criminal and civil cases, and whereas most citizens today viewing the prosecuting attorney's office as primarily organized to prosecute criminal cases, not civil matters, and whereas the board seeks to respond to the prosecuting attorney's statements, lessens the caseload of the prosecuting attorney's office, and allowing the prosecuting attorney to focus solely on criminal law prosecutions, and whereas the board has adopted purchasing policies pursuant to motion 460-96 and revised the motion number 130-14 at section 4C, establishing that all purchases with an estimated total cost of $50,000 or more require formal competitive sealed bids, and whereas the board wishes to request formal competitive sealed bids for corporation counsel to the Lapeer County, and therefore be it resolved that the Board of Commissioners hereby determines that the prosecuting attorney shall no longer advise and represent the county in civil law matters, and be it resolved, further resolved, that the Board of Commissioners engages the Mike Cox Law Firms, PLP, LLC, to serve as interim legal counsel of Lapeer County for a period of 120 days so that the board can engage in the bid process for selecting corporation counsel. And be it further resolved that the Board of Commissioners request formal competitive sealed bids from interested law firms to serve as corporation counsels in Lapeer County. Any discussion? Would the clerk please call the roll?
We have a motion.
We need a motion. Who makes a motion?
I make the motion to approve.
Support.
We have a motion and support. Would the clerk please call the roll?
Commissioner Warren,
Yes.
Commissioner Clark,
Yes.
Commissioner Henning,
Yes.
Commissioner Jarvis,
Yes.
Commissioner Kemp,
Yes.
Commissioner Snyder,
Yes.
Chairman Roy.
Yes. Resolution. Welcome, Mr. Court. Council, 620 days. So, thank you, Mr. Cox, for everything you've done for us and helping us resolve some of these issues. And we're looking forward to working with you on different things.
Thank you, Mr. Chair, and I'll hang around to the commissioners have any individual questions later.
Okay, that's fine. Thank you. So we need to, any commissioners have anything to go to the board?
Mr. Chairman, could I request, just because we did this in a little bit of a speedy manner. Well, no. We didn't go strictly by our general agenda rules. Could we offer another public time just so that if anyone wants to comment on what has happened or we currently, or generally we do that after we've done all of our business. I think that's a good practice.
Well, that's fine. If you want me to do another public time, I'll open another public time. Would anybody like to enjoy the approach during the third public time?
Does this mean that Mr. Conchu in the prosecutor gets off scot-free? Is that what this means?
No, it doesn't mean that.
Okay. Just checking.
Yeah. And then we were just talking about the county being liable for what they do, for what they do. So,
But isn't that what's happening to the county now? Is that not what is happening? This big lawsuit going on?
That has nothing, this has nothing to do with the lawsuit.
Okay.
the lawsuit is still going on. This has nothing to do with that lawsuit.
This was our concern for liability issues in the county with everything that has come out based on the lawsuit.
Yeah, this is what this does. It takes care of that issue. I mean, Judge Conchu actually owing the prosecutor all that money, things, and actually practicing, the prosecutor actually prosecuting in front of him. If the county has any liability, can we be sued? Can the county be sued for that happening? That was what this was all about. And we can always be sued, but our insurance policy basically covers it.
And this lawyer's going to stay on?
For 120 days.
For 120 days.
But,
While we do a competitive bid.
While we do
but
that.
he is allowed to bid.
Anybody else like to address the board during this public time? Hearing and seeing, no, want to close this public time. Do the commissioners have anything of interest to report this morning?
We want to put this out. We want to add this. Did you just get this handed to you? Why is this just coming to us right now?
That's just for next week.
For next week? Oh, so okay.
This is, yeah, we already passed this motion for authority day. This is just so we know what we're looking at next week.
Some of the remaining years.
Exactly.
This happens quite often.
In this case, they're ahead.
Now, do you have anything for the board this morning?
A couple of mundane things. I guess mentioned there is roast beef dinner next Thursday for the Lapeer Center. Usual time, usual place, usual amount. Next Thursday is also Economic Club, Dr. Ballard from Michigan State. And I think today's the date for sign up for those who are interested. Habitat dinner is Friday, November 9th. It's a good way to support Habitat for the county. And then, I guess a little more serious note, we didn't really discuss that resolution on corporate council, but I can't resist at least commenting that part of my personal concern has been about some of the comments that our prosecutor has put in writing about our fitness and our reliability to do the job that the public has voted for us to do. And I'm not sure why he made those comments, and I'm not sure how people perceive them, but I don't think, given the way those comments were made, that we could could ignore what was said. And it does affect our relationship with him and the work he does for us. So I think it's important we took this step.
Yeah.
Well, I guess I agree with that. My grandfather always told me, once you've hired a lawyer, you've already lost. And that can't be, no truer words were ever spoken. It's incredibly unfortunate. I never, in my 18 years sitting in this seat, never thought that we would be hiring outside corporation counsel. But I never thought anything like the events that have occurred could possibly occur in Lapeer County. So I guess the only other truer words are never say never, right?
Yeah, the only two comments I want to make both have to do with the actions also. And the first one is I do find it also very unfortunate and unregrettable. I think you'll find within the history of Michigan, it is the common practice of the prosecutor's office to be corporate counsel. Mr. Cox, in one of his earlier reviews, summarized it best when he said, whenever anyone has a relationship with an attorney, trust and loyalty are key components of that relationship. And clearly from the time prior to Mr. Sharkey's election, including up till now, his comments and actions clearly show that has been totally eroded, and we can't continue to have that type of relationship. So I think the action we took today was absolutely necessary. It's not for us. At the end of the day, we are elected to represent the people of Lapeer County. The cost ends up getting borne by the taxpayers, all the people that are working hard every day to support their families. So we're trying to protect. We talk about liability and things of that nature. We're trying to protect all the residents that we represent to keep legal costs and legal battles down. So it's unfortunate, but I think it was a necessary step. The other thing I think it's important to note, we kind of joked about it when we were having multiple people call one of our staffers on something, but I've mentioned it before. When the state constitution was crafted, obviously there was not a management class back then that talked about having clear delineation and lines of who your boss is, because we have this co-employer concept at the county level where all of these different elected officials, be they prosecutors or clerks or treasurers, we are co-employers with them. We have to work together with them. But I think it's important to note that when we talk about issues like the courts, when we have issues that come up, we are not a co-employer with the court. The court is their sole employer. So we're the fiduciary. We're the one that ends up getting the bill. So the discussions that we have today deal mostly with bills, mostly with the liabilities, mostly with having to deal with outcomes and the fallouts over this whole court mess. But when it comes to authority, we have no authority. We can't tell the chief judge how to organize his court. We can't tell the court administrator's office at the state level how to administrate justice throughout the state. We can't tell individual judges how to run their courtrooms. We cannot, we've talked about this before, going all the way back to the original prosecution of Judge Conchu. We cannot tell prosecutors what cases to file charges on and what cases to not file charges on. It's completely unethical to be getting involved as elected officials trying to intervene in that process of criminal justice. So I just want to point out again to the public that today, this was as a fiduciary of the county dealing with those financial ends, those financial means, but when it comes to how the courts are operated, they are not even a co-employer a partnership with us. They are their sole employer. They just happen to occupy the same building as we do, and we're the fiduciaries. And I think it's important for the public to understand that point. That's all I have to say.
Right. I know there's a lot of things I could say right now, but I think enough's been said. I don't have a lot to add. I do want to say congratulations to Cheryl yesterday. She had a great program for active shooter event. I think everybody in the county should attend any future ones that come up, but for businesses and stuff, the things that are going on out there. So I got a little off the where we were just to kind of change that format, but I think we heard enough there, so I want to pass it on.
Okay, I agree with everything that's been said. It's a sad state of affairs right now that we're in. But Attorney Cox did an excellent job. We all feel better. We know where we stand. All right, Cap.
Yeah, the workshop yesterday turned out really good. We had 220 signed up for the morning and 209 for the afternoon. They didn't all show up. No, I don't think we quite had that many there, but the morning session sure was full. There was hardly any empty seats, and he had set up for 230. So, and it was really good. I did, I see you guys have your microphones out. We need to put our microphones back up because if somebody comes shooting, you're supposed to throw things at them, and we really don't have a lot of things to throw at them. So anyways, I thought we need more knick-knack stuff and heavy stuff like rocks on display on our
Baseball bats.
I do want to comment. I'm going to throw that in, so you know. I do want to comment on what she's saying yesterday. And when you go to a meeting like that, and everybody comes away from that, some of them with fear in their heart, and everybody's just scared of everybody now. So you don't want to create that kind of a scenario. But the biggest part of that is to always be aware of your settings, wherever you are. Know a way out. Know how you got in and how you can get out. Because those things could pop up at any time, anywhere, airport, stores, church, wherever you're at. Just be conscious of the people around you. You think you're all friendly, but somebody might not be. And we're in a safe little town, but there's always a goofball in every little town. So always be prepared for that. But don't live your life in fear. That's the biggest thing I want to say. Except for the rest of that.
It did. It showed where a lady walked out of a gas station and parked, didn't even pay attention. There was a guy really loyal. They had actual videos of different things. So, and she was like, and he hit her with a crowbar, and she fought back. So he did leave, but. And then there was a case kind of like what we're sitting in, the Panama City in Florida, had a shooting. A guy, they fired somebody, and it was a school, and the guy came in, they fired his wife, and he was broken. He ended up shooting like 7 times. He missed everybody, and a police officer came and shot him in the hip and the shoulder, and then he shot himself in the head. So, and then the superintendent kept saying, well, he was shooting blanks. And they like, no, he wasn't. They put a hole in your notebook right there, and he shot himself. So, but they got it all on tape. And, so it was very, very educational on how to be aware of your surroundings. Like that. So.
Most important thing to what she's just saying there, talking about a setting similar to ours is, and it's just a natural reaction. When you're in a situation, I had a bullet or a gun pointed at my head, so I know what that feels like. It really is a life-changing experience. But the thing is not to freeze. That's our immediate reaction, is to freeze. Always be ready to act. So if something like that was to happen here, we all have to somebody else go. You got one guy shooting, you only got so many bullets. Somebody may get hurt, but if we're all moving, he's got a less chance to target, but we got a better chance of taking him down. Remember that in any setting you're in. Just yell, go, and everybody go after them, or figure out a way to get out. Get away from it if you can. Don't try to be a hero, but if you're stuck in the middle, you're going to go down. You might as well go down fighting. So that's the only thing you keep back in your head, but get it out of your head, because we don't live in that world. There's just a percentage of people out there who want us to believe the whole world's like that, and it's not. But be prepared.
The presenter was Dr. Ken Wolf. He did a really good job, and he does offer some other workshops. We did an evaluation on the back where a lot of other workshops that he does was checked. So I gave him the evaluations. That's how he gets paid, and asked him to please, tally up the back, let me know what they are, and maybe we'll look at something in the future. So it was very good, very interesting. So
Thanks for taking on that extra responsibility to organize that.
It's okay. You know, when I thought about how many workers we have going into home at the county level and you know, state level, you know, DHS, but you know, it was quite a lot, and I thought, wow, I've never seen a safety program on people going into other people's homes. So that's what started it all. And then when the churches were, you know, asking about active shooters, it was a good fit for everything. Good response.
She did a great job. Everybody needs to tip their hat to her. If you hear of any of them, whether she puts it on or somebody else, I would advise you to at least go get educated and learn a little bit about what's out there.
I was signed up and I was really disappointed. I couldn't attend.
We were going to tape it, but we forgot to tell the guy that was doing it to tape it. So I didn't get taped. Worked out good.
Thanks. Thanks, Cheryl, for doing that.
You're welcome. It was well worth the effort.
I'd also like to say, and I think I've already said it, you know, thank you, Mike, for Cox, for the way you put on the presentation and the work you did, and I mean, the documentation and the exhibits and everything that you used. I don't think anybody could have done a better job than that. And then this board had to take action because if you want to take a look, Lenny has it. He has the documentation of how cases and things have fallen off and how they're not being sent to district court. And we got some real issues here. So, I mean, it's...
I will add on to that. In personnel, Judge Bernard brought down a paper
That's what I'm talking
on the
about.
cases. And I did ask the sheriff for his how many tickets and things he has issued so we can see what's happening. But as it showed, the prosecutor's cases were down by 1,125. So if the sheriff's department, police department still are issuing the tickets and the rest are still up there, then there's a downfall someplace. And I know I talked to the sheriff yesterday. He's really getting upset because they're not prosecuting anybody. They're just sending everything back for more information or not enough information. And it's getting bad.
The issue she's talking about there, too, I'm hearing the same thing, and I've talked to Scott about that a few times. It's not just the sheriff's department. It's the police department up here. It's Meadow Moore. It's all of them having issues, and it's something that everybody's going to ask us what's going on. How come this is going on? We're trying to get answers. We can't accuse anybody of anything, but we're looking for numbers right now, and I've asked everybody publicly to give me those numbers so we can see who belongs in a part of that pie, where that money's got to be divided to, and why we have to pay extra money and take some money out of our pie so we can take extra counsel. We need to know those and what those reasons are and why we have to go to that level. So we're doing that to try to get to the public that these numbers are falling into place of what's going on. So we can kind of help get Lapeer County back to where it belongs.
You have to be real careful who you elect.
Yeah.
And you know, and who you support. A lot of those individuals that are having real problems with this prosecutor actually supported him. And you know, be careful when you do things like this. Yeah, it's dropped off. New filings. Basically, what it is, you go across the board from 2014, there was 1,610. You got 15, 14, 37, 16, 14, 54. Then we get into this prosecutor, 2017, 1,197. 2018, so far, 988. And that's not because we don't have crime in this county. So,
Well, the sheriff said his numbers have not dropped at all.
well, they haven't dropped. So what we need is
I move to recess.
Support. Meetings in recess.